Hello, everyone. Welcome to the uh, webinar, which is co-hosted and jointly organized by LAWASIA and the Law Society of Hong Kong. The webinar is on the topic of national security law for Hong Kong, balancing public order and civil liberties. My name is Christopher Leong. I'm the immediate past president of LAWASIA. I will be co-moderating this webinar with my friend Amarali. Amarali is the vice president of the Law Society of Hong Kong and the current chairman of the Constitutional Affairs and Human Rights Committee of the Law Society of Hong Kong. So as the session title suggests, this session would explore the new, or rather fairly new legislation applicable to the Hong Kong SAR, which is the National Security Law for Hong Kong. The official name, I'm informed, is the Law of the People's Republic of China on Safeguarding National Security in Hong Kong. And then I think for ease of reference, we would just refer to it as the National Security Law. It came into force in June of 2020, this year. And since then, and in fact, just prior to that, when it was announced the intention to come up with such a law, there were many comments and expressions, some of concern over this national security law, its content, its efficacy, and possibly its effect in various spheres within society, and even in the economic environment. And hopefully some, or if not all of those questions would be addressed or answered in the course of this webinar. We have a very distinguished panel of speakers with us, and we will do the introductions as and when we get to the panel, the speaker's presentation. But they will deal generally with key aspects of the national security law, including the offenses, the penalties under that law, the extraterritorial reach of that law, and whether or not it impacts upon the jurisdiction of the Hong Kong courts, the availability of due process, and the independence of the judiciary. I'm happy to inform you that for this session, we have delegates from across the globe, from Europe, from Africa, from the Middle East, from South Asia, Southeast Asia, East Asia, Australasia, the Americas. We have Canada, for example. We have the United States of America. We have Venezuela. We even have delegates from the Caribbean joining us, giving us a total of 38 jurisdictions and 375 delegates. So obviously, this is a topic of much interest to everyone, everywhere. And so without further ado, it gives me great pleasure to introduce the president of LAWASIA. He is Mr. Chung Wan Choi. Chung Wan Choi is, aside from being a president of LAWASIA, he's also the president of the International Association of Korean Lawyers. And that brings together under one umbrella all Korean lawyers, especially those who are practicing outside of South Korea. He is currently a senior partner of the law firm of Lee & Co. in Seoul, South Korea, and he is a co-head of the international practice group at that firm. So, Chung Wan, the mic is yours.
Thank you, Chris. Good afternoon from Seoul, Korea. It is my great pleasure to welcome you to today's webinar, which will be exploring the national security law for Hong Kong. LAWASIA is very grateful to the co-organizers of this event, the Hong Kong Law Society. My name is Chung Wan Choi, and I am the president of LAWASIA, the law association representing thousands of lawyers through its member bar associations and legal organizations in Asia and the Pacific region. LAWASIA and its organizational members work together to solve challenges facing our members within Asia and the Pacific region. And we encourage, as central objective, adherence to the principles of the rule of law, access to justice, and the protection of human rights. At LAWASIA, we also aim to enhance the knowledge and quality of practice of Asian lawyers through legal education and training. As you are aware, the national security law for Hong Kong came into force in June 2020. Over these past few months, both the law and its implementation have dominated media headlines globally. We at LAWASIA consider that now is an opportune time for experts on the matter to be given an opportunity to openly share their unique perspectives on and experience with the law. In the spirit of collaboration and shared learning, we are pleased to offer a panel of speakers from a variety of different backgrounds and with diverse viewpoints on the law. We look forward to providing our speakers with the opportunity for a robust yet respectable debate on a matter that many of us no doubt have our own unique opinions and perspectives on. Thank you to our panelists for giving up their time to join us for this event. There will be time allocated at the end of the panel presentations for our moderators and audience to ask questions. I have no doubt that notwithstanding the variety of views on this matter, all participants will engage with this process respectively. I would again like to extend my strong appreciation to the Law Society of Hong Kong for helping us offer this event and its continued support of LAWASIA. 2020 has no doubt been a challenge for us all. During this period of change and uncertainty, we at LAWASIA believe that it has never been more important for us lawyers to continue to question, learn, and develop. Through shared learning and collaboration, I believe we will be able to understand and find solutions to common problems across the region. Above all else, we lawyers must ensure that we continue to advocate all the interests of justice to prevail. By remaining connected despite the physical distance and by working together for a shared purpose, I have no doubt of our strengths to influence our region for the better. In the spirit of collaboration and connectedness, I would like to personally invite each of you attending today's session to consider additional ways of becoming involved in LAWASIA. Thank you again for joining us, and I hope you enjoy today's event. Thank you.
Thank you very much, Chung-Wan. May I now take this time to invite Ms. Melissa Pang, who is the President of the Law Society of Hong Kong and the President-elect of LAWASIA, to give her opening remarks. Ms. Pang.
Good day, everyone. Welcome to this seminar on national security law, jointly organized by the Law Society of Hong Kong and LAWASIA. Also, I have to thank LAWASIA for this very fruitful collaboration. The law of the People's Republic of China on safeguarding national security law in the Hong Kong SAR, which we just call national security law, is a very important legislation for Hong Kong. And it has attracted worldwide attention. And it is also one that has stimulated mixed reactions and heated discussion, both locally in Hong Kong and internationally. The national security law was passed by the Standing Committee of the National People's Congress. It is a national law of the PRC, and it is added to the list of national laws in Annex 3 to the Basic Law, which is pursuant to Article 18 of the Basic Law on 30th of June 2020. It took effect in Hong Kong on the same day upon Gazette of the Government promulgation. Prior to the passing of the National Security Law, the Law Society of Hong Kong has issued two public statements following respectively the issue on 28th of May of the National People's Congress decision on establishing and improving a legal system and enforcement mechanism for the Hong Kong SAR to safeguard national security. And also another important document, which is issued on the 21st of June, of the outline and explanation on the content of the draft law on safeguarding national security. Law Society of Hong Kong published our observation on the National People Congress decision and also our comments on the outline and explanation. We have also sent our comments to the relevant authorities. On 15th of July, Law Society of Hong Kong also organized an online roundtable discussion on the national security law. We have eminent speakers from Hong Kong and also from other jurisdictions. And it was well attended. We had over 700 participants. The national security law is already enforced. Any suspected violation of its provision will lead to arrest. A number of such arrests have in fact been made since July, and the national security law is being applied by the court in real cases. Now we can see certain provisions of the national security law are being enforced. There are concerns and queries surrounding the law. And today we are very pleased to have the presence with us many eminent speakers. They will share their views and updates on the national security law. We are also grateful that with the assistance of technology, despite the COVID-19 pandemic, we are able to proceed with this joint initiative of Law Society of Hong Kong and LAWASIA. It's important for us to connect with our participants, both in and outside of Hong Kong, to discuss this important piece of legislation. I wish you have to have an intellectual stimulating session, and I hope you'll find it informative and fulfilling. Thank you.
Thank you very much, Melissa, for your welcoming remarks. And as Melissa has said, the national security law has invited mixed reactions and of course heated discussions. And I think many of us would know that this would be common with regard to any security laws. By its very nature, such security laws usually contain unusual provisions that we will not normally see. And therefore, it is not unusual to have mixed reactions to it, heated discussions about it, and for such security legislations to be examined and picked through a microscope. And I think the presentations to follow by the speakers will be such an exercise for academically examining and discussing the national security law, its provisions, its effects, and what it may mean, not only for Hong Kong, but for the region and wider field than that. In fact, I think it is pertinent for everyone that has any dealings with or connection to the Hong Kong SAR. So I would like to start off. Thank you very much, Melissa, for that. I would like to start off the presentations with introducing to you Mr. Mark Daley. Mark is a council member of the Law Society of Hong Kong and a member of its Constitutional Affairs and Human Rights Committee. Mark is a human rights lawyer, originally from Canada, but has worked in Hong Kong since 1995, primarily in the areas of public law and human rights litigation, advocacy, and access to justice issues. He has canvassed, advocated, appeared in many cases, test cases, in the highest courts in Hong Kong involving, for example, the issue of permanent residency for migrant domestic workers, as well as in cases involving the refugee principle of non-refoulement in customary international law. Mark, as the Amnesty International's representative, has attended as an international legal observer, and it may be of interest for us in Malaysia to know this, at the trial in Kuala Lumpur, Malaysia, of the former Deputy Prime Minister, the current opposition leader of Parliament, Anwar Ibrahim, as well as the court cases of the immediate past Minister of Finance and is Member of Parliament currently in the opposition bench, Mr. Lim Guan Eng. Mark is an original member of Article 23, opposed to the proposed security legislation, and Article 45 concerned groups, and his firm was the winner of the Asian Legal Business Pro Bono Law Firm of the Year and Law Society Pro Bono Award. He is a speaker at the UNHCR in Geneva on human rights litigation and was a speaker at the 25th LAWASIA Conference on human rights and the rule of law. Mark, you have the mic. Thank you.
Can you hear me?
Yeah.
Okay. Thank you very much, and thank you for friends, old friends at LAWASIA, and for the opportunity to speak. Obviously, a very important topic for the development of Hong Kong. For those looking for answers to these questions on national security, they're probably going to be disappointed. And a fundamental theme running through my talk will be that the national security law just creates a lot of questions and uncertainty in Hong Kong. And I'll try to develop that a little bit further as we go. I've pitched my talk a little bit more for the international audience, and trying to summarize what's going on in Hong Kong is very difficult, because even if it's our day job, there's so many events going on that touch upon human rights in Hong Kong. You pick up the local newspaper and it's full of issues in Hong Kong at this time. So it's very difficult to keep up. I'll try to give a snapshot of what's going on of the significant issues. We can't go into the full background of the constitutional order in Hong Kong. It's important to know that the basic law of Hong Kong is meant to have the effect of creating Hong Kong as a separate region carved out from the rest of the country with its own legal system and its own system, thereby giving effect to the Sino-British Joint Declaration. So that's a proposition that I'll start with that is fundamentally important, that we're supposed to have in Hong Kong a system, and particularly the legal system, that is unlike the system on the mainland. So I think that's a core proposition that we have to start with, and it's very important when we discuss the national security law. At the outset, I think Christopher has mentioned my membership in the Article 23 concern group. So Article 23 is Article 23 of the basic law that says that the Hong Kong SAR should on its own implement and put in place security legislation. And I dug out in preparation for this talk, I dug out some of the pamphlets that we created some 17, 18 years ago when the Hong Kong government put forward legislation on security legislation. And we had a group of lawyers, the Article 23 Concern Group. I can show you a pamphlet, one of the pamphlets that we created. I did the one on sedition. And that culminated in a march of about 500,000 people who were objecting to the bill that was proposed by the Hong Kong government to bring in and refine the security legislation. So I don't know whether reflecting upon that, whether I should feel guilty about the fact that our objection led to the government the local government, Hong Kong government, not bringing in security legislation and not even attempting over the intervening 17, 18 years to try again. And in my view, that would be the appropriate process where some give and take and some dialogue, and the local government would try to bring in that again in consultation with local stakeholders. Unfortunately, that didn't happen. And so we've had the national security legislation effectively foisted upon Hong Kong by the NPC-SC. So that is the kind of the origins of the concern here. Now, I've got a paper. I'm going to refer to it a little bit. It is, and I thank the LAWASIA for putting it on the LAWASIA website, a paper on this topic that I put out shortly after the NSL came into effect, and titled "Hong Kong and the Premature End of One Country, Two Systems Experiment." Okay, and you can look at that. Christopher alluded to the fact that I was in Malaysia on more than one occasion as an international observer. And I write in here, I mean, to a human rights lawyer, there's something jarring to seeing draconian legislation in print. The last time I had that feeling was when I reviewed the Internal Security Act in Malaysia, and recognizing there are very few human rights protection and realizing its potential for abuse. So with seeing the national security legislation in Hong Kong brought back that feeling of vulnerability, and I'll try to elaborate a little bit more on that. One of the big problems, as I alluded to, was how this legislation came to be in Hong Kong. So there was no consultation at all with the local Hong Kong stakeholders, and some have called it the second handover. Basically, the way this has been foisted upon the Hong Kong SAR. Now, part of the problem that I see, by way of background, the slow erosion of the rule of law in Hong Kong is the overuse of interpretations and or direct legislation from the mainland. Again, initial proposition, Hong Kong was to be ring-fenced, particularly its legal system, from the mainland system. The original interpretation by the NPC-SC created a huge controversy in Hong Kong. The first interpretation on the right of abode cases in 1999. Basically, the result of that was the conservative legal community in Hong Kong had a march to demonstrate against that, because they recognized that would be erode confidence in the legal system, and where you override the Court of Final Appeal in Hong Kong. Unfortunately, there's been, instead of more restraint, we've had more interpretations and more, in my view, basically infusion of mainland law into the local system since then. Fast forward to the again, by way of background to the umbrella movement, again, another NPCSC decision is what triggered the umbrella movement, because that people thought they were going to have what was promised to them, what was democracy, and that the game was changed with the NPCSC decision that changed the game, reflecting that. This, now the national security law, I write in the paper, instead of a slow erosion, the dam has burst, because now it seems like this has become the norm, as opposed to restraint on these issues. I question the necessity for it, and many have as well. Key initial concerns, I'll just set out a few. One is, as mentioned, that because we don't have the normal legislative process, what we would say a normal legislative process in Hong Kong, a lot of concerns arise, because the concepts, the vague concepts that are used are not familiar to common law lawyers. We don't have when it comes to statutory interpretation, we don't have the how this decision, how this piece of legislation was arrived at, and so that creates a lot of concern as well. The power of interpretation being vested in Article 65 of this legislation, vested in the NPCSC, can undercut the independent exercise of judicial power by the courts of the region, and how this legislation, how this document sits with the basic law. I've seen different academics not come to a conclusion on this. It's one of the big questions is, with inconsistency, how are the courts going to interpret where the status of this is compared to the basic law and the in the Hong Kong SAR. Slogans such as "Liberate Hong Kong," "Revolution of our times" have been said that they are now national security crimes by many. Like I said, the vague and broad definitions without common law precedent, again, are going to create uncertainty in Hong Kong. Obviously, reserving the power, the Articles 55 to 57, reserving the power to remove suspects to face trial in the mainland, seems to be introducing extradition by stealth, which was the major reason for the massive demonstrations in Hong Kong last year, which led to the marches and a lot of the turmoil in Hong Kong. The National Security Council is not subject to judicial review, Article 14 of this legislation, which is a big concern, particularly to guys like me, who our expertise is in judicial review. And generally, the offenses are vaguely worded without the necessity for violence and are not drafted with the common law tradition, lack definitions. There's no definition of national security law, what national security is in the legislation. So it leads to fear, unpredictability, uncertainty, which is we would say, is contrary to the rule of law. Now, as mentioned, there was 2 million, almost 2 million people marching last summer in Hong Kong, and peaceful Hong Kongers, mostly peaceful, and demonstrating over a number of issues, mainly the extradition issue, but also the lack of democracy in Hong Kong. And we have not had any dialogue in Hong Kong on resolving those issues. That has been, and that's going to be a theme, another theme. That's the major concern with why we're in this place in Hong Kong right now. Now, update. Christopher alluded to the fact that even since the national security legislation, we've had another decision by the NPCSC. So further lack of restraint, I would say. And again, this was to disqualify, eventually leading to the disqualification of 4 opposition legislators. And that has led to the resignation of almost all the opposition legislators in Hong Kong. So again, and there is in the basic law, you'll see Article 79, there's a dedicated provision of the basic law, how to deal with disqualification of legislators. This has been effectively overridden again by an NPCSC decision. Johannes Chan, who many of you know, Hong Kong U professor, very well respected constitutional academic, he has said the basic law is becoming irrelevant. Okay, and he's not, I've known Johannes for a long time, he's not known for exaggeration usually of his comments.
Mark, can I just remind you, it's 2 minutes left.
Okay, yeah. Statistics, just very briefly, some of the statistics as part of the fallout from what's happened in Hong Kong. There's been 10,000 people arrested. Now that's not under the national security law, that's generally under the various provisions because of the protests. I'm a part of what I do in human rights as a refugee lawyer in Hong Kong. It's disappointing to see Hong Kong now producing refugees. We've had, I think there's 181 Hong Kongers who've applied for asylum in other countries. Some have been granted in Hong Kong and in Canada and in Germany. And 43.9% of respondents in Hong Kong have said that they would emigrate if they had the chance to leave Hong Kong. So these are some of the consequences. I won't go into all of them. Just very last thing, some of the other bodies that are talking about this, and we need to pay due regard to the UN experts who've made comments. I invite you to read the September 1st, 2020 very concerned UN experts on human rights who've made comments about what is happening in Hong Kong. And perhaps I'll leave it there for questions so that we can move on. Thanks.
Thank you, Mark. We'll come back to you during the panel session to enable you to complete. Obviously, you have a lot more things to say.
Yeah.
So may I now introduce Mr. Dr. Thomas So, who is the immediate past president and a member of the Constitutional Affairs and Human Rights Committee of the Law Society of Hong Kong. Dr. So. Yeah.
Thank you, Chair. Can you hear me now?
Can hear you.
Yeah,
clearly.
Okay, thank you. Thank you for giving me this opportunity to talk about the national security law. 10 minutes obviously is far from enough to explain in a bit more detail, given that the audience that we have, many of whom come from abroad, who might not understand the situation here in Hong Kong. So I would like to make use of my time, 10 minutes, to first of all, I think, it's very important, first of all, to understand the constitutional structure, first, within which Hong Kong sits as a special administrative region, in terms of the binding effect, legal binding effect, constitutionally, in Hong Kong courts of our nation's, China's constitution and its relationship with the basic law. The reason that I want to say this is that many people out there have been saying that the NPC and the NPCSC's decision or what they have done contrary to the basic law, which include obviously the passing of the national security law. So I think it's important, first of all, maybe I spend a couple of minutes, first of all, to tell people what the constitutional framework is all about for HKSAR. Now, Hong Kong is a special administrative region. We all know that. Hong Kong is part of China that is set out in Article 1 of our basic law. And Hong Kong special administrative region is report to, belong to the central government's authority. That's, I think, set out also under the basic law. So the constitutional source of the basic law that we all talked about, that defines the system, the rights and obligations and everything happening here in Hong Kong, was passed as a law back in 1990 by the National People's Congress in accordance with a constitutional power under Section 31 of our Constitution. Now, under Section 31 of the Constitution, it's very important. It says that the National People's Congress can set up a special administrative region and its systems by passing a law. So it was in accordance with this constitutional power that the NPC exercises power to pass the basic law and set up special administrative region, which is part of China, which reports to the Central People's Government, and also set up the systems at the time that's set out in the basic law. So it was the National People's Congress NPC under Section 62, subsection 13 of our Constitution to make the decision on the setting up of the SAR and its systems. And it is relevant to NSL, which I will talk about later, because it is the same constitutional power that NPC exercised in laying down the background in the legislation process for the national security law to come into place. So the second point about basic law, all the powers that comes from the basic law comes from the authorization from the NPC. Now, if you look at the basic law, there are different provisions talking about the NPC, National People's Congress, authorized Hong Kong to do this, Hong Kong to do that. Now, if you look at Article 2, the independent judicial power and order, the high degree of autonomy that Hong Kong enjoys all come from an authorization from the NPC. And the authorization was given to the Hong Kong government to exercise their power and discharge their duties in accordance with the basic law. That is the one country, two system, and all the rest of it. So in other words, where there are express provision in the basic law where powers were authorized by central authority, Hong Kong has a power to do that based on that authorization. But where basic law has no provision to deal with certain matters, then Hong Kong does not have the power, and Hong Kong has to go back to the central authority and ask for authorization enabling them to do something that basic law has not provided for. Now, this classic example is the co-location. You know, if you remember a few years back, we had to set up a high-speed rail in Hong Kong. We had to set up a separate custom in Hong Kong that enable mainland custom officers, immigration officers to operate in Hong Kong. That's a situation not covered by basic law. And we had to ask for NPCSC to do a decision, to make this legal. Okay. So the point that I want to make is for powers that are not given or powers that have not been authorized or is absent from the basic law, those powers are exercisable only by NPC or NPCSC. Now let's turn to the national security law. National security is a piece of national law passed by the NPCSC, and it applies to Hong Kong through Article 18, Annex 3 of the basic law. So it's a national law that becomes a Hong Kong law through our basic law machinery. And this passage of the law was acted in accordance with the decision made by the NPC back in May. So you have an NPC decision that laid the foundation of the legislation, then authorized NPCSC to legislate. So the constitutional power behind at the national security law is almost as high a level as that of the basic law. So that also explains that the same power that I just mentioned under the Constitution that NPC exercised in passing the basic law is the same power cited in the decision, this time authorizing NPC to pass the national security law. And it therefore explains why the NSL actually ranked a bit higher than the local domestic legislation. Okay, now there are important authorities important principles to observe under the NSL. Article 4, Article 5 expressly bring in the human rights protection, the ICCPR, the two international human rights conventions, saying that the exercising of the rights in enforcing this law need to be in full compliance with protection of human rights, with all those protections laid down under international covenants. And on top of that, if you look at the NSL, it cites a few important principles that I want to explain. First, again, it reiterates that Hong Kong SAR is part of China, and that Hong Kong SAR is a local administrative region, enjoy high degree of autonomy and come directly under the Central People's Government, which are the same two articles that I have just alluded to, Article 1 and Article 12 of the Basic Law, which set out the very basis of where Hong Kong sits in the whole regime of China. Hong Kong is not a separate body, is not even a quasi-separate entity sitting away from Hong Kong, from the mainland China. It's part of China. When one looks at the constitutional basis standing of Hong Kong, it sits inside the China constitutional structure. So that is, I don't think it is right to say that, you know, the basic law actually kind of shield Hong Kong away from the rest of the system. I personally do not agree with that statement. But the separate legal system guaranteed under the basic law came from the authorization, as I just said, from the NPC, in accordance with the provisions of the basic law and in accordance with the one country, two system principle. Okay. So the duties also are to safeguard the sovereignty, unification, and territorial integrity of PRC as set out in the NSL. And there is a few important points that I also want to raise, which is this. Now, some people would say that, you know, if one looks at the constitutional structure of Hong Kong, we only need to look at the basic law. And I think that now even Hong Kong court's judgment accept that that is not correct. When we look at the constitutional structure, we look at the basic law, and we also look at the constitution. And under the constitution of PRC, Article 52 and 54, Hong Kong, Chinese citizens, Hong Kong residents, Chinese citizens have an obligation to protect national security. So there is a duty on people in Hong Kong to safeguard that. Okay, and do I have last 1 minute, right? I'm looking at.
Yeah, you can.
Yeah. In terms of national security, some people say under the basic law, you have Article 23. Now, Hong Kong people do not legislate. So why are you kind of forcing this into Hong Kong? Now, first, national security, to protect national security, the responsibility is on the state. Is on the state. Is on basically us. Is on China. It is not on Hong Kong. And the Article 23 itself, if you look at it, it doesn't say even a word of national security. It only cites 7 types of activities that that goes into the question of protection of sovereign rights or territorial integrity rights. When one considers national security in the context of China and Hong Kong, one needs to look at the national security law in China, which was passed in 2015. If you look at that, there are at least 7 or 8 types of national security they talk about. Sovereign rights, territorial integrity, economic security, financial system security, national resources security, food safety security, environmental security, communication, cybersecurity type of security. All type of security can be considered as national security. So Article 23 only deals with 7 types of activities that fall under 1 type of securities. So the question therefore is the obligation to protect national security fundamentally is still on the state, but not on Hong Kong. So that is the reason why it needs the NPC to pass a decision, lay a foundation for NPCSC to legislate. Now the wording, if you look at the wording, is to establish system to protect national security and enforcement mechanism. This is the kind of system that I was saying under Article 62, subsection 14 of the PRC Constitution. When one talks about NPC's duties is to have the power to set up SAR and set up its systems. Okay? That includes the system that we talked about under the decision that require NPCSC to pass the national security legislation for Hong Kong. I think I will stop at that. Thank you.
Thank you very much, Thomas, for that presentation. And obviously, you have touched upon several areas. I think that would be of much interest and would require much more time, I think, for a deep dive. And I don't know whether the time allocated for the Q&A would be sufficient for that. But I think building on your last point, I think your position is that although Article 23 of the Basic Law of Hong Kong provides jurisdiction to the legislature of Hong Kong, or LegCo of Hong Kong, to enact laws pertaining to some aspects of national security. But my understanding of what you said is that it only pertains to 7 types of national security. The broader general area of national security comes within the purview of the central government to legislate. I now move on to the next speaker, and I'm delighted to introduce to you Professor Cheng Ge. He's a professor of public law in Ko Guan Law School, Shanghai Jiao Tong University. He taught at Peking University from 1998 to 2003, and the University of Hong Kong from 2004 to 2014, before taking his current position. He also took visiting positions at the University of Michigan, University of Toronto, Duke University, and Columbia University. He specializes in constitutional law, law and technology, and legal philosophy. Professor Cheng, please. Professor Cheng, you have to unmute. Professor, can you unmute your microphone? Professor Cheng?
Okay. Can you hear me now?
Yes, we can. Thank you.
Okay. Thank you very much, Chairman, and thank you, the audience. I'm very glad to share my view on Hong Kong national security law. Actually, I myself is a Hong Kong permanent resident by taking normal residence in Hong Kong for over 7 years continuously, according to Article 24 of the Basic Law. But I haven't come back to Hong Kong for a long period of time. Actually, by now, the distance between mainland China and Hong Kong has become the farthest because of the COVID pandemics. Okay, so I'm very glad to share my view on Hong Kong national security law. And I'm also very glad that Dr. Thomas Sowell has already stated the issue in the general framework of Chinese constitutional law. We need to understand that Hong Kong is part of China. Hong Kong's constitutional order is part of the national constitutional order. Although for many Hong Kong lawyers, for example, P.Y. Law, a very famous barrister in Hong Kong, in his book, Judicial Construction of the Basic Law in Hong Kong, he argued for the so-called second founding. He argued that although Hong Kong basic law is made by outsiders, what he referred to as outsiders is actually the National People's Congress of China. He argued that although the basic law of Hong Kong is made by outsiders, but because Hong Kong got its unique common law tradition, therefore Hong Kong courts can interpret the basic law to the effect that Hong Kong can have a second founding with its new constitutional order. Such an idea is actually very popular and which lead to a situation that many Hong Kong lawyers consider Hong Kong as an independent constitutional order. So it is very necessary to situate Hong Kong's constitutional order in a larger constitutional framework, that is People's Republic of China's constitutional order. Okay, so because Dr. Thomas Sowell has already touched upon that issue, therefore I can move on to some very specific issues to answer certain concerns about the national security law in Hong Kong. The first concern is whether it is necessary. Many people have raised the issue whether it is necessary for the National People's Congress Standing Committee to enact a national security law for Hong Kong. For example, in her written testimony for a House Committee on Foreign Affairs in the United States hearing on July the 1st, 2020, University of Hawaii legal scholar Carol Peterson, who was my colleague when both of us are in the University of Hong Kong. Carol Peterson questioned that need for national legislation, noting that Hong Kong has legislation prohibiting violence, and those laws are being enforced against those who allegedly committed acts of violence during the recent protests. Hong Kong also has its own statutes prohibiting most of the activities specified in Article 23, as well as laws prohibiting terrorism. The legal gap, if there was one, was small, and there is no reason why the local legislature could not have completed the process of implementing Article 23 in a manner that complies with the International Covenant on Civil and Political Rights. I think that is a good question. Why Hong Kong failed to perform its duty under Article 23 of making a national security law? Article 23 of Hong Kong Basic Law actually imposed a duty rather than given an autonomy for Hong Kong to enact on its own a law to protect national security. But nevertheless, the Hong Kong Special Administrative Region government's difficulty in fulfilling its obligations under Article 23 is not because of inaction. As early as 2002, Chief Executive Tong Chi-hua initiated the process of making Hong Kong's national security law and proposed the National Security Bill for public consultation. But before the draft was discussed in the Legislative Council, the Civil Human Rights Front organized a July the 1st march in 2003, which incited over 500,000 people to take to the streets to demonstrate, which led to the withdrawal of the draft in September of that year. That bill is actually roughly a collection of the existing law, putting the existing legal rules together to form a new bill. That is very conservative, very moderate, but nevertheless, it encountered tremendous protests within Hong Kong. That set up a very bad precedent in Hong Kong. Thereafter, every action taken by the Hong Kong government to enhancing the one country part of the one country, two system principle would encounter opposition in Hong Kong society. And we have seen many of them from the anti-national education movement in 2012, the Occupy Central movement against the constitutional reform plan in 2014, to the anti-fugitive amendment movement in the last year. After this series of movements, Hong Kong's social order has deteriorated. The rule of law has been undermined. The lives of ordinary Hong Kong people has been severely negatively affected. And that is the general background for the enactment of national security law in China this year. Okay, so that is to answer the first question, whether or not it is necessary for the National People's Congress Standing Committee to enact a national security law for Hong Kong. Because after 23 years of handover, Hong Kong has yet to enact a national security law according to Article 23. And the second concern is whether the law is too broad and overreaching. People would say that many people had said that the national security law in Hong Kong criminalizes 4 broadly defined categories of offenses, including secession, subversion, organization, and perpetration of terrorist activities, and collusion with a foreign country or with external elements to endanger national security. Okay, so to say that those provisions are too broad is actually to say that all legal rules are broad. Okay, so those rules are not broader than any other general rules would be. Okay, so they are open to interpretation. Actually, Hong Kong, even before this law, already got some provisions related to national security. The majority of them are in criminal offenses ordinance. And the Hong Kong court has developed expertise in interpreting such legal provisions. And because even after the national security law in Hong Kong was enforced, actually the majority of such cases would be submitted for the Hong Kong courts to decide. And therefore, we don't need to concern about whether or not those provisions are too broad, because before they would be implemented, they would be interpreted by Hong Kong courts. And we need to trust Hong Kong courts in properly interpreting those provisions, taking both human rights protection and safeguarding national security together and balancing them according to developed legal doctrines and legal methods. Okay, so actually what is lacking in the existing laws in Hong Kong is that foreign political organizations or groups are prohibited from conducting political activities. That is clearly defined, clearly mentioned in Article 23 of the Basic Law. In Hong Kong's criminal offenses ordinance, there are already provisions about secession, subversion. but previously there were no legal provisions to deal with the so-called foreign-related national security crimes. So the new law actually touched upon this issue, and which also gave concern to the jurisdiction issue. Okay, so for example, according to Article 29 of the National Security for Hong Kong, it is mentioned that the institutions, organizations, and individuals outside the mainland Hong Kong and Macau of the People's Republic of China referred to the first paragraph of this article shall be convicted and punished for the same offense. Okay, so if foreign organizations and persons colluded with Hong Kong persons and organizations to commit one of the 5 types of crimes, including propagating actions to endangering China's national security, for example, waging a war against the PRC, something like that, would under the jurisdiction of national security law for Hong Kong. Therefore, people would argue that this type of jurisdiction is overreaching. Okay, so covering the behavior of foreign entities and persons. But this is also not very strange because the United States got many of such laws. And whether or not such claimed jurisdiction could be realized actually depends on many issues, including legal judicial cooperation between different countries, and also depends on whether or not those persons who were alleged of committing such crimes would travel to the territory of China, including Macau and Hong Kong. Many of you may—
2 minutes, Professor.
Okay, I would finish very soon. Okay, so many of you may know that the United States has exercised its territorial jurisdiction very often, including requested the assistance from Canada to arrest Meng Wanzhou, the chief financial officer of Huawei. Therefore, such jurisdiction is not uncommon. Whether or not they can be realized actually depends on many different issues. Okay, so that is a response to the concern on whether or not the jurisdiction is too overreaching. Actually, I have many things in my mind, but I do not have enough time to share with you. I hope that we can have more discussion in the discussion session. Okay, thank you very much.
Thank you, Professor. I think we will give you time during the discussion part to complete what was unsaid, just as was for Mark Daley. I'd like to now introduce Ms. Elaine Pearson, who's the Australian Director at the Human Rights Watch. I won't say too much, but allow her to present her time. Thank you, Elaine.
Thank you so much to LAWASIA for hosting this discussion. I'm not a constitutional law expert, so I'll say that I'm not going to focus on those aspects. But what I do want to focus on is, I guess, the ways in which the national security law violates international standards. And I want to examine a bit about the impact it is having now some 5 months after it's come into effect. And frankly, what we see with this law is that there isn't a proper balance between security and civil liberties. We see this national security law as an aggressive assault by authorities in Beijing on the basic freedoms of Hong Kong people. And our concerns relate to the way in which it can be used to prosecute peaceful speech, to curtail academic freedom, and to generate a chilling effect on fundamental freedoms in Hong Kong. And I think that the national security law does contain provisions that will have a devastating long-term impact on human rights protections. So I won't go into too much of, I guess, the context or the history, because I think previous speakers have already outlined the history in Hong Kong, that this law was really drafted to respond to the periodic protests that emerged over a number of years that really brought daily life in Hong Kong to a standstill. And I think Mark already outlined some of the background to those protests, people's unhappiness with backtracking on certain commitments to universal suffrage and electoral reform. There was also reference to the Occupy Central movement, and more recently, the concerns about extradition. And we certainly acknowledge that particularly more recently, at the protests, there were acts of violence, which certainly need to be addressed, and the perpetrators need to be held accountable. At the same time, we have also documented police violence at those protests. And we note that police officers still have not yet been held to account for excessive use of force. But our position is really that existing laws could be used to address those acts of violence. And instead, what we have with the national security law is a new law that makes it easier to prosecute peaceful acts of free expression. So already we heard the reference to, the 4 types of activities now that are criminalized: secession, subversion, terrorism, and collusion with foreign forces. All of these carry a maximum sentence of life in prison. But the definitions of these crimes are overly broad and are vague. So, maybe if I just give one example, the crime of subversion, for instance, criminalizes any act that seriously interferes, disrupts, or undermines the functioning of the Chinese or Hong Kong governments. And this definition readily includes peaceful protests. Both the crimes of secession and subversion make criminal acts that don't involve force or the threat of force, meaning that peaceful actions such as speeches that are advocating certain ideas can violate the law. And certainly we've seen, in the mainland, the way in which these sorts of vague criminal offences have been used against people who have been promoting human rights. So, for example, the prosecution of Liu Xiaobo, the Nobel Prize winner, the economist Ilham Tohti, who was also imprisoned for separatism because he was advocating for equal treatment of ethnic Uyghurs. The other concerning thing that is of concern to us is the extraterritorial jurisdiction. So it means that someone who is talking about Hong Kong independence in a place like Australia or the UK could find themselves running afoul of the terms of this law. And that could take place in a classroom, that could take place in an international Zoom conference like this one. So let's talk a little bit about impacts. And, so far there have been, I think, just over 30 arrests under the national security law, as far as we're aware. And these cases have included things like shouting pro-independence slogans, displaying pro-independence banners, protesting, speaking critically online, and also fundraising to support protesters to go and live and study in Taiwan. Peaceful acts of free expression are things that are protected under the International Covenant of Civil and Political Rights, which we all know that Hong Kong has ratified. So, we are very concerned that the provisions of this law, do not meet international standards. And, I would say here that Human Rights Watch is very critical of national security and terrorism laws in many countries around the world. And I've been very critical of Australian counterterrorism bills and measures that don't meet international standards. So we will always speak up if these laws violate rights. But the problem with Hong Kong's law is that it's vague, it's nebulous, and while governments do have the ability to suspend civil liberties in times of crisis, it is still important always that those measures meet the test of being necessary and proportionate. And they also should not be arbitrary in their application. And certainly we do not see Hong Kong's national security law meeting that test. I don't think we're alone in having this view. The UN Human Rights Office and UN expert bodies have also expressed concerns about the national security law and how the legislation can lead to discriminatory or arbitrary interpretation and enforcement. And there was reference earlier to a September letter by UN special experts. And in that letter, the experts said that this law lacks precision, it may not meet the required thresholds of necessity, proportionality, and non-discrimination under international law. We also know that foreign governments have also been concerned about the way in which the national security law will erode the rule of law in Hong Kong. And we've seen a number of governments, including Australia, the UK, Canada, and New Zealand, suspend their extradition treaties with Hong Kong because of concerns over this law. One other problematic aspect is how this law allows for the creation of specialized secret security agencies, the way in which it can deny fair trial rights. It provides sweeping new powers to the police and increasing restraints on civil society and the media. The national security law, for example, in part 5, allows for the establishment of an office for safeguarding national security in Hong Kong. Now, this effectively bypasses Hong Kong's law enforcement agencies. This office is not subject to oversight by the Hong Kong government, and it has the power to handle certain cases and give certain cases to China's courts and give them jurisdiction over certain sensitive cases. So what have we seen, I guess, since the passage of the law? Well, I've already mentioned we've seen 33 arrested, and we've seen 3 prosecutions initiated. We've also seen the chilling effect. We've seen activists preemptively have to flee Hong Kong. They've been compelled to leave because they feel vulnerable and at risk of prosecution because of the lack of certainty around this law. Political groups have preemptively decided to shut down or dissolve themselves. We've seen a number of international media organizations and international NGOs move out of Hong Kong, set up in other countries. We've also seen the way in which the national security law is being used to intimidate and silence civil society. So for example, the Hong Kong Alliance, which has organized Tiananmen vigils in Hong Kong for more than 30 years, since 1989, is now being attacked and accused of subversion and collusion with foreign forces. And even journalists trying to cover the developments in Hong Kong are now finding it difficult to find voices in Hong Kong who will speak up critically about this law. And that's because those who have been outspoken, some of them are now in prison, and some of them, frankly, are terrified and are too scared. So this is all part of the broader chilling effect. We've also seen some threats to freedom of expression outside Hong Kong. We've seen several overseas activists who allegedly are wanted under the national security law, including US citizen Samuel Chu, and various Hong Kong activists who have left the territory. We are seeing how the national security law is resulting in both censorship and self-censorship. In part, that's because of a new national security law hotline, which encourages people to report others who may be violating the law. So it creates this environment of distrust. We've seen changes to the way education is taught in Hong Kong, and a ban on certain pro-democracy books. So, early in July, the Hong Kong Education Bureau issued a notice to all schools, ensuring that students understand the importance of national security and to remove any books that may possibly violate the new law. So, we see that this law, in many ways, it is changing the very fabric of Hong Kong society. And I think for some businesses, they feel like, well, we're not political, so this doesn't really affect us. But, I would certainly argue that in many ways, it is effectively turning Hong Kong into a territory, pretty much like any other part of the mainland. And, obviously you have a lot of businesses that do operate in mainland China, but, the history of Hong Kong is very different. And the promises that were made under the one country, two systems are not being kept. And I think that is the issue. I totally agree that a lot of people in Hong Kong want security, but I think many of those same people in Hong Kong also want accountability, transparency, and rule of law. And they don't want their civil and political rights that they've taken for granted for many years suddenly to be dismantled. I'll leave it there and happy to answer any questions.
Chris?
Yes, thank you very much, Elaine, for that presentation. I think we are moving now into the panel discussion, where questions can be posed to the speakers. Primarily, first, I think by the moderators. So, Amrali, shall I start off with one question?
Yes, please do.
Yeah, sure. Okay, so I think we have a question. I have a question for Mark, and of course, feel free for the any of the panelists to jump in. I think there's been some concern, or rather, there's been a lot of concern expressed with regard to how the provisions of the national security law would be consistent with the rule of law. But when one asks that question, I think that there is a pre-question to that question, and that is, what is the understanding of the rule of law? So, you know, the person asking the question regarding rule of law may have a different understanding from the person they seek an answer from. So perhaps, Mark, to what extent are differing ideas of the rule of law at play when we discuss concerns over the national security law? For example, I think, what is this? I think in Article 5 of the national security law, it expressly provides that the principle, and I read here, the principle of the rule of law shall be adhered to in preventing, suppressing, and imposing punishment for offenses endangering national security. So it is clearly mentioned or embedded in the national security law. But I suppose the question is, what is meant by the rule of law? You know, is your understanding, my understanding, the Hong Kong authorities' understanding, central government's understanding, the ordinary citizens of Hong Kong's understanding of the rule of law, are they the same or not? Mark?
Yeah, no, thank you very much. I think a lot of the concerns and this experiment, the word I use, the experiment of one country, two systems, revolves around two, let's just say, two different understandings of what the rule of law means. And I think going forward, there's going to be a lot of discussion and debate, and it would be good if there was more harmonious dialogue on these issues and grappling with so we can get to the heart of what the issue is. I always try to I promote the United Nations and the rule of law. There's a website, and it has a definition of the rule of law. I try to ground certainly what I do as a human rights lawyer in UN documents, and so I'd invite people to look at that view of the rule of law, which includes participation in decision-making and transparency and separation of power, and all persons being accountable and lack of arbitrariness. And so that's the place where I would start. And a lot of the concerns about how this legislation was implemented and how going forward it adheres to any of those standards is a problem. And I've looked very closely. I'm at the situation on the mainland, and read a lot of those documents that are translated into English. And we know that there has been a Xi Jinping over the last few days has talked about the rule of law. And this is a quote from a newspaper. I don't have the full translation yet, but that the rule of law is to ensure loyalty to the party, the country, the people, and the law. And that's so I think we have to grapple with quite different understandings of the rule of law when we go forward and discuss these issues. Again, I refer to the UN documents, and I know Elaine has highlighted some more of out of that document. The UN protections. I'm heartened by the fact that the Zhang Jun, the UN, China's permanent representative to the UN, has said this, and this is fairly recently. He said, "We need the UN to safeguard fairness and justice, which are the legal and moral foundations for an effective UN." He goes on and promoting again the UN, and we would say that you can't disassociate general UN, bodies to the UN experts that are making all these comments, and we would think that there should be more transparency and let's adhere to those standards for everybody, either in the mainland or in Hong Kong.
Yeah, thank you, Mark, for that. Amberali?
Yeah, let me just go. Thomas, Thomas, can you hear me?
Yes.
In following on from Article 5 of the National Security Law, I noted from the National Security Law that at times it says this law, as in capital. In the Chinese, it means National Security Law. In Article 5, when it uses the word law, it uses small l, law.
Yeah.
And you also have in Article 8 of the Basic Law, which talks about which laws will continue in Hong Kong after 97, that's defined as common law, rules of equity, ordinances, subordinate legislation, as well as customary laws. So obviously there's two types of laws that are mentioned in the national security, and I think it might be interesting for our delegates to try and get some idea about those two definitions that they use, not definitions, but the use of the word law.
Yeah. Well, thank you, Amarali. When reference is made in the NSR to this law, capital L, obviously it means the national security law, that piece of law itself. Okay. And because the national security law is a national law, but is focusing and has become part of the Hong Kong law. So insofar as the NSL applies in the Hong Kong context, where people generally in Hong Kong are required to comply by the NSL law, the interpretation of the term, in my view, in accordance with the law, not capital, small letter, means all the laws that are applicable here in Hong Kong, right? So all the laws applicable in Hong Kong, as you have quite rightly pointed out, are set out under Article 8 of the Basic Law. Those that Hong Kong SAR inherited from the colonial past, okay, passing the Article 160 of the Basic Law test, because at that time, before the handover, there were groups of people from the NPCSC actually looking at all the laws, all the written laws applicable at that time in Hong Kong, and then work out what laws should not be inherited and what law should be inherited. That there is in fact an NPCSC decision I think in February 1990 that set out very clearly that they have done this exercise. And so for laws that are allowed to continue to stay in the statute book of Hong Kong SAR after the 1st of July 1997 belongs to those category of laws that are allowed to be inherited. Okay. And then the second part, of course, are new laws passed by LegCo after 1st of July 1997, and also national laws that become domestic Hong Kong law pursuant to Article 18 also become part of Hong Kong laws. So the rule of law that Mark has just kindly referred to, that is to be practiced in Hong Kong, obviously, are the legal principle and the rules within the structure of the Basic Law that continue to apply. If you look at, the NSL Article 5, the all, people are equality before the law, transparency, judicial decision need to be reasoned, right to have an opportunity to be heard. All those continue to be the legal principles that we need to follow, including the government, including the enforcement agency of the NSL here in Hong Kong. They all need to follow those principles under the rule of law that we practice in Hong Kong.
Thomas, can I just ask a continuation question from that, which is on Article 57? And obviously from Article 55 onwards, it talks about the special effects of the office of that safeguarding national security from Article 55 to 61.
Yeah. So
in Article 57, it uses the word in accordance, when the authorities referred to in Article 56 of the NSL exercise powers in accordance with the law, they use the word small l law, and legal documents, etc., issued by those authorities on their decision to take mandatory, etc. So here they're using the word small l law, whereas Article 5561, the rest of it uses capital L law. And of course, in Article 56, it talks about the prosecution body to prosecute, and the Supreme Court, People's Court, shall designate a court to adjudicate it. So any a response for you about how what we might call the law, small l, would be applicable in relation to Articles 55 to 61?
Yeah, that's a very valid point. Now, the premise of exercising jurisdiction over national security cases primarily rests upon the central authorities. Okay, because of what I've just said earlier on, the responsibility is on the state to kind of protect national security. So the premise, in my view, the primary position is that national security cases jurisdiction rests on the central authority. But under NSL, because of the one country, two system, the central authority decided that a large chunk of the cases they would allow Hong Kong SAR jurisdiction, enforcement agency, government, police, prosecute, DOJ, and the court to deal with, whereas they retain a portion where they are of the view that those cases, Hong Kong SAR as a regional government would have no ability to deal with. Then those cases, central authority resume jurisdiction. And those cases are set out under Article 55. So what Article 57 says is that once Article 55 kicks in, meaning jurisdiction reverts to central authority, then the criminal procedure law that applies in mainland applies, which makes sense, because if the jurisdiction goes back to the central authority, then we should follow the mainland procedural law. And so if you look at that in that context, Article 57, if you ask me the question, if that second paragraph of Article 57, when exercising jurisdictions over cases pursuant to Article 55 of this law,
yes,
blah, 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 the law enforcement and judicial authority referred to in Article 56, which are the mainland authority, shall exercise powers in accordance with the law. The law would mean the applicable law in the mainland context.
Right. But would the mainland courts then call expert evidence on Hong Kong law to be given in the mainland courts?
Well, I think it then depends on what matters need to be decided by the court. I mean, if there are issues that need to be decided by a mainland court that need to consider Hong Kong law, obviously they need to consider foreign law or Hong Kong law expert opinion.
So if I just stop you, Thomas, Mark and Elaine, we've now got this situation where you have Article 55 onwards that relates to matters which Hong Kong may not be able to convert, and you have the others which relate to Hong Kong. So my question, interesting one probably, is given that you've got two different systems of law applying, and if you talk about the limitation and derogation of power, just in quick words, how do you think the Syracuse principles would apply to the two? I'll ask Elaine to start first, if I can. Do you understand what I'm asked?
I think so. I mean, I think, look, our concerns are the same kinds of due process concerns that we have also raised, for many years, with respect to the mainland. And so, in these certain cases that will be transferred, to mainland agencies. So under Article 55 to 57 of the National Security Law, we are concerned that then they will be deprived of the procedural protections that exist under Hong Kong's legal system. So that, certainly is one element that is of concern for us, the way it sort of sets up this separate channel.
Would you, Mark, since you've been an observer, what kind of procedural elements would you like to introduce now that we have the law that allows what Elaine has said could be considered? I mean, hypothetically.
Well, yeah, I don't know where to begin. I mean, I think the elephant in the room, certainly for most Hong Kong people and international independent observers, is the concern about the mainland legal system. The World Justice Report has ranked the mainland legal system on the Rule of Law Index as 88th. Hong Kong is 16th. So the mainland hasn't ratified the ICCPR. So how's that going to work with that, with the provision, Article 4 or 5? So I think that's the elephant in the room here, so to try to treat this as the exercise comparing the mainland system to the Hong Kong system, I think most people would want the Hong Kong system. I mean, even our fellow members, the Law Society, we go around and promote the Hong Kong legal system. So it's somewhat inconsistent to be welcoming, and it's an unenviable task, those that do it, to be welcoming this encroachment on the Hong Kong legal system when it's seen as our pearl for the Pearl City. It seems rather inconsistent to be doing that.
Mark, can I just ask you a follow-up question on what you said? Article 4 talks about recognition, application of international covenant, civil and political rights as far as the national security law is concerned. You've obviously said that China hasn't implemented the ICCPR at the moment, but given the fact that this law is a law in China and it's confirmed in Article 4 that it does apply, how would you argue that is applicable under, or do you think it would not be applicable under an Article 55?
Yeah, doing human rights litigation here in Hong Kong for 25 years, I can say that traditionally the Hong Kong courts have been very conservative, and the balance is to have decisions where the human rights provision prevails. They're few and far between. So this unique aspect, my initial concern that there's no experience on the other side of interpreting the ICCPR provisions if it's going to come to being interpreted by the NPCSC. So again, how is that going to then filter down to Hong Kong as a precedent? I'd have huge concerns about that process.
Well, let's just, Professor Zhang, do you have any comments on that you can share with us? You have to unmute, Professor. Professor Chung, you have to unmute. Not unmuted yet.
Right.
Yeah.
Okay.
Yeah. Okay. Okay.
Yes. I would like to draw your attention to Article 40 and taking it together with Article 55. Article 40 actually provides that the Hong Kong Special Administrative Region shall have jurisdiction over cases concerning offenses under this law, namely national security law, except under the circumstances specified in Article 55 of this law. Therefore, for me, the majority of national security law related cases would still be tried by Hong Kong court, applying Hong Kong law. And the Article 55 imposed very strict conditions on in which situation cases would be taken over by the Office for Safeguarding National Security of the central government in Hong Kong. And in such case, first of all, there should be a request by the government of Hong Kong. And then the request would be approved by the Central People's Government. And only then the Office for Safeguarding National Security would take responsibility over the cases. And the article specified 3 types of situation. So when we are considering those 2 articles together, I don't think that many cases would actually be taken charge by the Office for Safeguarding National Security. Okay, that's my comment.
Professor, if there was a case under Article 55 provisions, would Article 4, the ICCPR, be applied, just from your view?
Okay, so
difficult question, I know.
Actually, I think it will be taken into consideration, but with whether or not it would be of binding force is another issue. But I think that PRC court, which got jurisdiction over such cases, will take ICCPR into consideration.
Okay, that would be interesting from what Mark said earlier, and it would be interesting legally. But Christopher, I think we have a lot of questions in the chat box. I think we should move, with your permission, to the questions, if that's okay. Would you like to take the questions?
Yeah,
There's
sure.
So many.
I think, thanks, Amarali. I think we have a few questions from the delegates. I think constitutionality of the national security law, and Mark Daley was focusing on the effect of the national security law and the Hong Kong people's reaction. So the question posed was, what is Thomas's opinion in terms of the chilling effect? And we have quite a few questions regarding the chilling effect, so I'll group them together. What is Thomas's opinion in terms of the chilling effect of the national security law causing in Hong Kong, and the fact that it is not welcomed by part or most of the Hong Kong people? The other questions in the same category are, is the national security law causing a chilling effect in Hong Kong? Has the national security law a chilling effect on journalists and human rights advocates? If so, how can this be addressed? And is it a position of the national security law on one hand versus freedom of speech, freedom of assembly, freedom of protest, freedom of opinion, and freedom of procession? So actually, I think this question, when grouped together, need not necessarily be confined to Thomas. Any members of the panel, please jump in. But I would invite Thomas first to give his views.
Thank you, Chris. That's a very good question. To start, I would like to say this. The national security law, which applies in Hong Kong, is not a piece of legislation just to protect Hong Kong's security. It is a piece of legislation to protect the whole nation's security. So I hear people saying time and time again that, look, Hong Kong people do not support Article 23 legislation. They demonstrate and against the passing of such a legislation. So why force upon them to do such a thing? I think the answer to that is this. Hong Kong is part of China. Whether or not passing a piece of legislation to protect the national security is a matter for the state. And that is because we need the NPC decision representing 1.4 billion Hong Kong people. So Hong Kong should not just consider from its own perspective as to whether they like or they do not like the passing of such a legislation, because under the Constitution, under the Basic Law, Hong Kong SAR, and under the PRC Constitution, Hong Kong Chinese citizens have an obligation to protect China's national security. So it is a duty, it is a constitutional duty, and it is not a choice. So that is my first answer to that. And as to the chilling effect, I remember whenever there is a new legislation that comes out that require a lot of adjustment to people's behavior, how we do things, obviously, normally you would have resistance from the community. I remember vaguely when the AML legislation came out, anti-money laundering, all right, professional bodies, bankers, and everyone suddenly realized that if they do not adjust the way how they do business, they do more KYI due diligence, they might fall foul of the law. And a few of our members had to go to jail because of that, okay, just failing to follow some new regulations. So at that time, there was chilling effect to business community. And you ask yourself, is it a right thing that we need such a legislation? And if so, we just need to consider how to adjust in order to make sure we do not fall foul of the law. Okay. And I think that much is my answer, and I'll leave it to the other speakers to have their comment.
Chris, there's a question directly for Elaine. So after your question, maybe you can put that one to Elaine.
Yeah, sure. Perhaps Elaine, would you like to answer the same question regarding the chilling effect?
Yeah, I'd be happy to talk about that, and I guess particularly the impact on the media. I mean, I think we have seen a deterioration in press freedom in Hong Kong, this year. I mean, we've seen the way in which, well, this actually preceded the national security law, but there's been an incident where journalists were pepper sprayed by police. We've seen RTHK suspend their popular satirical program in June, and following political pressure. And then, of course, following the national security law, we saw the very high profile raids of the Apple Daley and the arrest of Jimmy Lai. And so absolutely, I think, the message that this sends when hundreds of police officers descend upon the headquarters of a newspaper that has been, very strongly pro-democracy, is that, we are here to implement the national security law. And, I think that sends a very strong message, and it has sent a message of fear to people in Hong Kong. But I do know, it's been quite interesting to see the inventive ways, Hong Kong people have tried to express their solidarity by taking out advertisements in the Apple Daily and so on.
Yeah.
Elaine, there's one more question on the chat group. It says, if I may read it, question to Elaine: human right is important, undoubtedly, but if human right reaches an extent which would harm national security, i.e. the Hong Kong protests and US Black Lives Matters, protests which lead it to casualties, can the statement human right overrides still stand? And one more question from Sri Lanka, which is the effects for transitional justice. So perhaps you'd like to take it, and maybe Mark, if you want to answer those two questions, because they're directly to you.
Yeah, I mean, I guess on this issue of getting the balance right, yes, human rights can be suspended in times of crisis, basic civil liberties, but it is very important that those limitations are necessary, are proportionate, are time bound. And so, yes, you know, if you have a situation where protesters are causing a threat to life, and if that's happening, you know, in the United States, if that's happening in China, if that's happening in Hong Kong or Australia, you know, absolutely the police should be taking steps to address that violence. But I think the problem is that we're not just seeing laws that are being used to address violent or threats of violent behavior. We're seeing that it's actually being applied in a much broader way, so that, you know, people who are, you know, unfurling banners that are pro-independence are also actually being targeted and can be targeted by the terms of this law. On the transitional justice, I mean, I guess, you know, this is probably more of a question about international accountability. If domestic accountability mechanisms fail, you know, I don't think we're there yet. I think there has been a lot of discussion, you know, at the UN. We've seen a number of governments, I think 39 governments, raise concerns about human rights violations in China, from Xinjiang to Hong Kong. And we've seen a number of special rapporteurs call quite strongly for a new UN special procedure on Hong Kong. And in fact, I think on China generally. And so I think, you know, it remains to be seen whether these mechanisms to really, I guess, monitor the impact of various laws on human rights, whether those UN mechanisms will be set up. And if they're not, then, you know, it's I guess, those next steps for transitional justice.
Mark, anything to comment to that?
Yeah, just again, when we're dealing with human rights and balancing, and you know, we're looking at the title of this this forum. Human rights is always about balancing, and certainly I would say my view is that the balance is way out of whack when it comes to the national security law, and again, refer back to there are international norms on this, and the UN comments look at those very closely about how the balance is out of whack. Like you mentioned, the Syracuse and the Johannesburg principles, look at those. And Hong Kong people, they're very well educated on the international norms on these things, and they don't want to limit their civil liberties. They'd like to see everybody have those civil liberties, and so I think the balance is way out of whack here, and that's the big problem. And one issue we haven't raised is the fact it's quite a litmus test when you have the UK revisiting whether they'll send judges to sit on our Court of Final Appeal or not, because of what's happening over here. And we've already had one judge resign, an Australian judge, reportedly because of what's going on. So that's a litmus test for our legal system in general, and the erosion of the rule of law.
Well,
Chris, perhaps we should ask questions from the commercial world, apart from the legal world. Do you want to take those? It's the first questions on the. Is that okay?
yeah, go ahead, Emily.
Yeah. So I know there are a lot of lawyers, but also we have people who are not lawyers asking questions relating to national security. One of them is the estimated impact such law may have Hong Kong exports. Another one says how NSL impacts Hong Kong as an international legal and dispute resolution services center in the Asia Pacific region. And what is going to be the impact of this law on the economy? So those are all economic issues arising from national security. Anybody would like to take that?
Yeah, well, just very briefly, international markets, business rely on truthful information, and when you've got concerns and censorship going on, and you've got right now no opposition to bring to light issues in the Legislative Council, all of those issues are a big problem for the financial community. And not to mention just the straight substantive issues of falling afoul of national security law. If you inadvertently finance somebody who has views that somebody may not like, and you get caught up. So I think there's huge concern. What does it mean to collude with foreign entities? I don't know. We've only had the first prosecution under the national security law, but you can ask 10 different lawyers and they'll all come to different answers, and that's the problem: lack of legal certainty that's been thrust on the Hong Kong system.
Yeah, Thomas.
Yeah, Thomas. Yeah.
Yeah, I just want to comment on from the business perspective. The Article 29 of the National Security Law gave rise to a lot of gray area back then, but I think in a paper that was sent out by the government, Hong Kong government, answering queries from the international business community, the government made it very clear that for an offense to be prosecuted under Article 29, the foreign collusion offenses that Mark just now was saying, that is unclear. The government's position is that you need to have evidence to prove that there is a specific intent to endanger national security behind all those acts. Then the government would prosecute. So meaning that I think the government is making it clear, because the government appreciates that legislation like this might give rise to a lot of confusion, people worried about this and that, particularly the Article 29(4). I think, at one time, people start worrying that branch offices or multinational companies situated in Hong Kong might have to follow instructions from the head office when they're subject to US sanction, for example. Then that might put them in a very difficult position, might fall foul of Article 29(4). I think the government then reacted in that particular letter, clear the air in that the position that the government takes, because I think I can't remember which article of NSL, Hong Kong governments have this committee that can discuss and decide on how the NSL is to be implemented and is to be enforced. And I think they reacted this time quite quickly in clearing the air. And so financial institutions and the international business community, at least in that particular aspect under Article 29, get a bit of ease of concern. So the requirement for Article 29 prosecution require, now the government has clarified specific intent to endanger national security before a prosecution would be made. I just want to make that point clear. Thank you.
Okay. Just coming back to an earlier comment, I think was made by Mark with regards to the actual circumstance that is playing out in Hong Kong with regards to a couple of judges. So there's a comment here in the Q&A box, not a question, but a comment from Hong Kong. And I read the comment. It says, this is not a question, but I would like to say that given whatever uncertainties arisen from the Hong Kong national security law, Hong Kong courts will make an impartial and independent adjudication. For those who are not familiar with Hong Kong judiciary is famous for its independence. And in fact, prominent foreign judges from other common law jurisdictions still sitting on Hong Kong highest court. So that's a comment from a Hong Kong resident, a lawyer. And there is a question by another prominent Hong Kong lawyer, which connects to that comment. And I will pose this question. The question is posed to Professor Chung, and it says, what is the reason for Article 44? So Article 44 of the National Security Law provides that the chief executive shall designate a panel of judges from the magistrates court, the district court, the court of first instance, the court of appeal, and so forth, in consultation, no doubt, with the chief justice. But there is a special empanelment of judges for the sole purpose of presiding over national security laws. The tenure per designation is for 1 year. Judges who have previously made any comments that are deemed to be against national security, or judges who have been designated and who are then deemed to have made any comments that are contrary to national security, will be removed. So the question, therefore, from this prominent Hong Kong lawyer is, what is the reason for Article 44, namely designated judges to preside over national security cases, if it is said that Hong Kong judges are famously independent and impartial? Why dilute the independence in this way? Professor Chang, you have to unmute your microphone.
Okay. Actually, that's a very good question. For my perspective, actually, the purpose of Article 44 is actually that national security cases is a very specialized type of cases. And it cannot be totally independent of political values, because when we're talking about national security, we need to have certain understanding of political matters. Okay, so actually loyalty to a particular country or allegiance would be necessary for a member of the judiciary to be able to take in China's national security interest seriously. Okay, so we cannot ignore that nature, that part of the nature of national security issues. It's also about expertise. Okay, because of the speciality of national security issues. Maybe the reason for this article is to allow the chief executive to choose from those judges who have tried related cases, who have developed a certain degree of expertise on that regard. That is my brief comment.
Yeah, thank you. I think we are about to quickly run out of time. So perhaps I could just quickly shoot off a few of the questions that have been put. Some are directed to specific speakers, but anybody can jump in. There is a question posed to Mark, and it says for Mark, Mr. Mark Daley's statement, basic law carved out Hong Kong from the rest of China. And the question is this: is it referring to the one country, two systems principle as set out in Article 5 of the Basic Law, namely that the socialist system and policies shall not be practiced in Hong Kong SAR, and the previous capitalist system and way of life shall remain unchanged for 50 years? Or is it a comment on Article 1 of the Basic Law, which states that the Hong Kong SAR is an inalienable part of the PRC? And does Article 12, the Hong Kong SAR shall be a local administrative region of the PRC, which shall enjoy a high degree of autonomy and come directly under the central people's government, meaning that Hong Kong shall be considered as having the right to declare independence. So I suppose to put it in a nutshell, and this is a question arising from your comment, Mark, where you said basic law carved out Hong Kong from the rest of China. Really, Mark, is there a difference between autonomy and independence?
Well, yeah, I think there is, and I think there certainly, if I said anything to indicate that that the basic law and the Sino-British Joint Declaration allow for independence, that would be incorrect. I think we just would want to strictly follow the basic law as it's set out, and what often doesn't get mentioned in trying to justify these things are it has to also faithfully implement the Sino-British Joint Declaration, and that's a treaty that's registered with the United Nations, and so that aspect as well. Always when you're trying to paraphrase things using terms like carved out or whatever, perhaps you get yourself into trouble. But I think it's just following the Sino-British Joint Declaration and the basic law, and faithfully implementing that how we had hoped it would be, and as it did for at least a while until this drip has become a faucet of a running river of interpretations that is the problem.
Yeah, thank you. I think I'm going to lump a few questions together. There's a question to Thomas, and the question is: would Mr. Thomas find there's been abuse in the use of the national security law by the Hong Kong government or the Hong Kong police force when we see arrest or prosecution based on mere display or shouting of certain slogans once used in the 2019 extradition movement? So I suppose in a nutshell, really is the intended use of the NSL to curb freedom of speech only. And then if there is anything that one finds in terms of shortcomings of the NSL, there's another question that says that whether or not the NSL can be amended or can be repealed, and if so, by whom? And then it dovetails with a question from Japan, and this is addressed to whoever is willing to respond. And it says this: any law may contain deficits. However, even bad laws could serve rights of people with principles that the judiciary reviews and interprets them independently. And representatives of the Hong Kong SAR people have the power to control and amend laws. I'm afraid, however, it seems that the autonomy vested in the Hong Kong SAR could not maintain such principles anymore with the national security law, or that the administration is not interested in sticking to such principles. Do you believe that the national security law could function to serve rights of people without such principles? So in a nutshell, I think these questions go to one, what do you do when the law is being used, or some would say abused, to arrest people who have merely exercised their freedoms of speech and expression by shouting slogans? And if there's anything wanting in the law, it usually is addressed, or the check and balance usually are the judiciary and the legislature. But in terms of the NSL, it seems that these check and balances have somehow been blocked. So how do you believe that the NSL could then function to serve the rights of the people of Hong Kong without such principles?
Okay, Chris, let me try to do my part now. The enforcement of the law, if you look at, I probably know where that question comes from. You look at the exact wording of Article 20. It requires not only a mere act, but then it requires an act with a view to committing secession or undermining national unification, okay, in separating Hong Kong SAR or any other part of PRC from PRC. So you need an act plus basically the mens rea and also the specific intent. So if you have an act, unfortunately, if you commit an offense fall squarely within Article 20, then you get prosecuted, you get convicted. And if it is just a mere act which does not fall within the requirement of the offenses under Article 20, you get acquitted. I think that, you know, it is just like any other new legislation that impose new obligations on people. Second, the question is how do we, you know, the enforcement of the law to protect the rights of Hong Kong people. As I said, first of all, protection of national security is for the whole nation, just not for Hong Kong. So I think the point is, in enforcing this law, how do we make sure that the suspect or the defendant who are in Hong Kong are given a fair treatment, legal representation, fair trial, and all the rest of it. You know, it's been cited under Article 4 and Article 5. We have an independent judiciary. The whole system works in the same way in Hong Kong. So I honestly do not see there need to be any additional worry. Thirdly, whether this law can be repealed or amended, yes, it can be. But because it is a national legislation, I think the only body that has the power to do this, either to amend it or to repeal it, is the NPCSC. Okay. I think it's very much out of Hong Kong SAR's jurisdiction. And as I said, because this is a national law, it's there to protect national security of our nation. I think I've said enough.
Yeah. I think there's just two more questions, and they're short questions. One is, does the Office for Safeguarding of National Security have the power of arrest in Hong Kong? And if so, how does it fit in the current law enforcement regime where the police force of Hong Kong is the main authority carrying out that function? That's one question. The other question, I think, is from Sri Lanka. And I think this may be a response to what Professor Chung may have said. And in a nutshell, I think what the question is about is, how do you pigeonhole a judge purely on his findings or comments in a particular case when he came to a decision based on the facts of the particular case and the comments were made with regard to the particular case? How can then one pigeonhole that judge? Perhaps Professor Chung could go first and then.
Okay, I would like to answer the second question. Actually, as I mentioned before, national security issue is related to political loyalty. It needs someone to totally understand the interest of national security of China. And from the comments, from the extrajudicial comments of judges, basically, we can see how the judge has been taking national security of China, taking that issue into account. Okay, so that is a signal of political attitude, and the national security issue is by definition political. Okay, so actually, of course, we cannot simply pigeonhole a judge simply by looking upon how he comments about national security issue. I believe that the chief executive in Hong Kong, in designating judges, would look upon the whole profile of judges, with extrajudicial comments as one of the elements. Okay, that's my brief answer.
Yes, thank you.
Chris,
Christopher, can I just follow up on one on that, just to pose a question? Because
Yes.
again, as I said at the outset, there's so many things happening here, it's hard to keep up. And a recent headline from one of our mainland officials talking about patriotic judicial education. How do we even define patriotism? And I pose that as a question. For if a judge aspires to UN standards and democracy, is he unpatriotic?
Yeah, my comment actually sort of follows on a bit from that if, political loyalty is something that's going to be taken into consideration, and there is this power, of the chief executive to handpick certain judges for national security cases, then, I do worry that this threatens the somewhat legendary, independence of the judiciary in Hong Kong. And, obviously of concern that in, certain complicated or serious cases, that those cases would be referred to the mainland. But I also just wanted to comment, a little bit on, I guess, this issue of, we shouldn't be too worried because, the collusion with the foreign forces, it would need to endanger national security. I think this is the whole problem is, that definition of what constitutes endangering national security or, harming national unity, these are quite nebulous concepts. And, unfortunately, we have seen, previously in the mainland, a number of cases where, charges of separatism or subversion have been used against people in the mainland simply for, raising certain human rights issues, raising certain, political reforms, or, speaking out for equal treatment for certain citizens.
Thomas, would you have any last comments?
Yes, Chris. About the Article 44, so-called the requirement of patriotism. Now that word does not appear in Article 44, and I don't think that is a legal term. But the point that I think Article 44 gives the power to the chief executive to designate judges is that the primary principle of the whole thing about setting up a system to protect national security, as I said many times, is on the central people's government. So everything rests on central people's government shoulder. And by that, the central people's government, insofar as the formation of the judicial system in dealing with the judicial proceedings resulting from the enforcement of national security law, rests upon the chief executive, who is the top official here in Hong Kong, accountable to the central people's government as well as Hong Kong people, to have that right. And that right comes from the central people's government for them to assign, for her to assign the appropriate judges from an existing panel. It's not any Tom, Dick, and Harry, existing panel of judges. Why? Well, we have judges, many judges from all different jurisdictions with different qualifications. They're all very good because they come through a very stringent recommendation process. But we appreciate also that not many judges, not all of our judges, for example, can read Chinese. All right, so all these factors I think are important. Judges, do we have sufficient judges who can understand the language, who can understand how our government, how our central people's government work, who understands the constitution, the PRC constitution? I mean, we know that as a fact in Hong Kong, not many lawyers in Hong Kong practicing actually are familiar with Chinese constitutional law, as well as how our central people's government work. So all those factors are important. And the second paragraph that deals with it, which is a minimum standard that a judge would not be qualified to sit on the national security cases is where those judges has already expressed a view, which may be considered as endangering national security. And that is nothing new, because if you look at judicial officers' requirement, if they have behaved in such a way that they might be considered as biased, here in certain cases, they should be asked to be recused. So I personally do not think that there is anything strange about this right to designate judges, particularly after the passing of the national security law. This designation would have to be done in consultation with the Chief Justice from an existing pool of judges, and for only a term of 1 year. So that is the point that I want to respond. And a short answer to the first question, I think, Chris, you just mentioned, somebody asked about the power to arrest.
Yes.
The power to arrest, the power of the Office of Safeguarding National Security, right? I think the answer is actually in Article 40 and Article 55, in that, yes, in circumstances where Article 55 applies, where the whole proceedings happened under mainland law, then of course the Office of the Safeguarding National Security of the Central People's Government would have the power to enforce the law, including arresting, investigation, all the rest of it, in accordance with the mainland Chinese commercial criminal procedure law.
Thank you very much. Amirali, would you have anything else?
No, I'll let you close, Chris.
Okay, thank you very much, everyone. We have obviously, due to the interest in the topic, we have certainly run over time. I would just do certain formalities before I close, and also to leave you with an overriding thought. It is not a question, but after 2 hours, I think the sense that I get from the question really is with regard to where does the law, the national security law, leave Hong Kong and the people of Hong Kong in terms of the environment that they have come to know and the laws that they have come to know. So I start off first by framing this with reference to Article 1 of the National Security Law, which says, in effect, that the National Security Law is enacted for the purpose of ensuring the resolute, full, and faithful implementation of the policy of one country, two systems, under which the people of Hong Kong administer Hong Kong with a high degree of autonomy. So Article 1, which is embedded in the National Security Law, recognizes that it is for the Hong Kong people. And then if you look into the other provisions of the National Security Law, which provides for the apparatus for dealing with matters under the National Security Law, then you may make reference to Article 12, which establishes the Committee for Safeguarding National Security, which comprise of 9 members of Hong Kong government officials. Article 13, that provides for the Secretary General to that commission to be appointed by the central government. And Article 15, which provides for the appointment of a national security advisor to that committee to be appointed by the central government. And then Article 16, which provides for a department within the police force of the Hong Kong SAR to be established, to be named the Department for Safeguarding National Security. The head of that security is to be appointed by the Chief Executive after seeking written opinion from the Office for Safeguarding National Security established under Article 48. The members of the Office for Safeguarding National Security are appointed by the central government. And then Article 18, which then provides for the establishment of a prosecution division and the prosecutors of that division shall be appointed with the consent of the Committee for Safeguarding National Security. The head of that prosecution division shall be appointed by the Chief Executive after seeking written opinion from the Office for Safeguarding National Security. And then there's Article 44, which provides for the Chief Executive to designate judges onto a panel to preside over national security cases. And then Article 47, which provides that the court handling national security cases shall be bound by a certificate issued by the Chief Executive as to whether a particular act involves national security. So that may or may not impact on certain defenses that defendants may have. And then there's Article 11, which provides that the Chief Executive of Hong Kong shall be accountable to the central government and shall make an annual report to the central government. So you have that as the general apparatus. So I think the panel of speakers have rightly focused on the particular provisions of the NSL, particularly with regards to the offenses, the penalties, and so forth. One should, I think, also look at the overall umbrella apparatus that will be implementing this law. I leave you with that thought and for you to discern for yourself as to what that means and the effects of that. I wish to thank the President of LAWASIA, Chung Wan Choi, the President of the Law Society of Hong Kong, Melissa Pang, who is the President-elect of LAWASIA, my co-moderator, Amirali Nasir, of course, our wonderful speakers, Mark, Elaine, Thomas, and Professor Chung, for giving us your time, and of course, for your invaluable thoughts and insights. I can guarantee you that the conversation on this particular topic and with regard to the national security law will not stop here. It will continue and it will evolve. Bear in mind that it has been less than 6 months since the enactment of this law. So although we can speak of it from a theoretical, academic perspective, we would also like to see how, in reality, the law would be effected, how proceedings and particular cases would be handled. And that, I think, itself, later on, would add to the conversation and may, in fact, change the conversation with regards to the national security law. I think that there may be some questions. I apologize if we have not been able to deal with all of the questions, but the LAWASIA Secretariat will go through the questions and see if any have been omitted, and we will try to get you written answers, very short, brief written answers. I don't wish to burden the panel of speakers further than necessary. I would also please invite all of you to visit the LAWASIA website at, I should know this but from memory, but I'm afraid I don't. I think it is www.lawasia.au. Please visit the LAWASIA website to look out for any future events. We also would welcome you to join LAWASIA as members. In fact, it is with your active participation and your robust exchange of views. We do not pigeonhole, compartmentalize, and only recruit members with a certain leaning, thinking, affiliation. We welcome all and sundry. That is what makes LAWASIA rich and enriching. So thank you very much, everybody. I would ask and invite Amirali to say any last words that he may wish, but this is all from me, Chris Leong from Kuala Lumpur. Hope to see you all again very soon. Thank you.
Thank you very much. I think this is going to be very important. Hong Kong's a commercial city. Many companies have to make commercial decisions in every respect. And I think this is going to be continuing. Thank you everyone for participating. Have a great evening, afternoon. Thank you.
Thank you. Thanks.